As we cap off our study into constitutional law, we are going to explore principles like judicial review. We are going to dive even deeper into the central ideas of the Constitution, and we're going to examine further the relationship between the national government and the state government. As we begin, we will learn about judicial review. In essence, what judicial review is the power to declare laws and presidential acts unconstitutional. What this means is that if Congress were to pass a law that violated the Bill of Rights per se, then the Supreme Court can declare it unconstitutional, thereby voiding it. The power of judicial review was gained through the court case Marbury v. Madison in 1803, when the Supreme Court voided a law passed by Congress. Judicial review went on to be expanded to different legal situations, like in 1810 in the court case Fletcher v. Peck, the Supreme Court declared a state statute unconstitutional for the first time, thereby expanding judicial review from declaring national laws unconstitutional to also declaring state laws unconstitutional. Then, in the case Martin v. Hunters-Lessee in 1816, the Supreme Court declared full supremacy over the state court system, meaning that the Supreme Court now had the power to overrule the decisions that state court systems came to. And finally, in 1821, in the case Cohens v. Virginia, the Supreme Court claimed the power to review state criminal cases in addition to civil cases. Next, let's discuss some of the big ideas established by the Constitution, such as federalism. Federalism is basically the idea that the national government and the state governments work together. So when establishing this idea of federalism, the Constitution granted enumerated powers to the national government, which basically means there were a bunch of powers in a section of the Constitution that were listed one after another and granted to the national government. However, the Constitution also reserves powers to the state governments, meaning that the national government cannot impose on those powers reserved to the states. In addition to these enumerated powers granted to the national government and reserved powers granted to the state government, the residual authority clause gives the national government the power to make any laws which are deemed to be necessary and proper in order for the government to fulfill its duties well. What this means is that the national governments and state governments both have their own specific powers, but the national government also has the power to be elastic in a sense, meaning to stretch their power in order to fulfill the nation's needs. However, this is only if the laws the legislative branch makes are related to the enumerated powers of the national government. In addition to this idea of federalism, one central idea of constitutional law is that of checks and balances. What this means is that although there are three branches of our government, each of them still holds some power over the other. For instance, the judicial branch's power of judicial review gives them some power over the legislative and executive branches, in that the judicial branch can declare their laws or acts unconstitutional and void. One also extremely important idea outlined in the Constitution is the protection of rights. When I say protection of rights, I am talking about protection of individual rights, but in addition, I'm also talking about the protection of states' rights. One way the Constitution protects individual rights is through the Bill of Rights. This document consists of the first 10 amendments to the Constitution and grants individuals, for example, the right to bear arms, or the right to a trial by jury in front of their peers, or the protection from cruel and unusual punishment, the right for people to speak their mind, to worship in whatever way they see fit. These are all protections outlined in the Constitution in order to protect the rights of individuals in the United States. Another way the Constitution protects the rights of individuals is by restricting certain government actions. One example of this being that the government cannot pass ex post facto laws. What this means is that the government cannot pass laws that declare an action a crime after it has been committed. For instance, if you were to tie your shoes using the bunny ear method, and then next week the government passed a law that said tying your shoes using the bunny ear method was illegal and all those who have done it in the past can be punished by death, that law would undoubtedly be deemed unconstitutional by the Supreme Court, because the Constitution says that the government is not allowed to pass ex post facto laws. In addition to these individual protections, the Constitution also protects rights of the states in that it reserves powers to the states that the national government cannot interfere with. Finally, as we conclude this unit in constitutional law, let's examine the way the national government and the state government is related and what this means for us in our study of constitutional law. So when it comes to authority in specific areas, the federal government is limited but supreme. Essentially what that means is, in this figure below, the federal government is above the state government in whichever areas the Constitution grants it power in. However, the state government has much more general power, meaning that the state government has the ability to act in many more situations than the federal government does. This idea that the national government and state government have different areas of authority is called dual sovereignty. Initially, our government functioned under this dual sovereignty principle, where the national government and the state government had their own specific spheres of authority, and they did not interact with each other. There was no crossover, no working together. It was simply the national government had power over ABC, and the state government had power over DEF, and that's how it was. However, over the years, we have moved into more of a cooperative federalism system, which means that, yes, the national government has power over ABC, and the state government has power over DEF. However, sometimes the national government helps out the state government in certain situations, and the state government gives the national government assistance in certain situations. For instance, even though schooling is a power typically reserved to the states, the national government still has the Department of Education, where they help provide state governments with grants and things in order to educate the youth of our nation as effectively as possible. Finally, one important idea to understand is the doctrine of preemption. Preemption has to do with what happens when the national government takes action. By taking action, I mean when the legislative branch passes a law or the president passes an executive order or something of the sort. What happens when the national government takes action, much like how the Constitution is supreme to all other laws, national law is supreme to state laws. So when the national government takes action, if there is any state law that contradicts national law, it is thereby invalidated. Additionally, state law that could potentially contradict national law in the future is invalidated. So if the national government takes action and later down the road the state government passes a law that contradicts the federal government's prior law, that law that the state government just passed becomes invalid. Now, the idea of preemption might seem relatively simple to understand. the national government is just superior to the state government, so the national government wins when their two laws conflict. However, when we bring the idea of dormant federal powers into the question, it becomes a bit more complex. What dormant federal powers mean for this idea of preemption is that in some scenarios, the national government has power to act in a situation, but they don't always act immediately. So, for instance, if the national government has the power to declare war and they haven't declared war yet, then their power to declare war would be considered a dormant federal power. In relation to this idea of preemption, dormant federal powers mean that when the national government could act, but they haven't acted yet, then any action by the state government is preempted, which means prevented. So in our example, if the national government has the power to declare war and they haven't declared war yet, that doesn't mean that the state of Minnesota can declare war on Canada because they don't like them. In conclusion, through our study of constitutional law, we've covered numerous things. What constitutional law is, what the difference between state and national constitutional law is, some of the very central ideas to constitutional law, what judicial review is, how the national and state governments interact, what their relationship between is the two, and really, this all goes to show us that constitutional law, just like any other type of American law, is extremely complex and takes a lot of study to understand. However, it all comes back to these central ideas that we've learned about. It's actually very understandable to the everyday person.